Hello, thank you for joining us today. We're going to talk about developments at the EEOC and what this means for your organization. As with other webinars that we have presented, our goal is to help employers get out in front of potentially challenging issues. Briefly about my background, and I hate to admit it, but I've been practicing employment law now for more than 30 years. And in that time, I've represented management, I've worked as a mediator, I've also performed human resources services such as training, implementation of policies, and early intervention. So what's new? The Equal Employment Opportunity Commission released its 2024 to 2028 Strategic Enforcement Plan and also draft harassment guidance. Both of these developments will have a substantial impact for employers. So our program today is going to talk about aspects of the Strategic Enforcement Plan, a bit of background and aspects of the draft harassment prevention guidance, and then some takeaways, steps that you can take to get out ahead of these developments. So the EEOC exists to help enforce the anti-discrimination laws, including Title VII, which covers race, color, national origin, religion, and sex, the Americans with Disability Act, and the Age Discrimination in Employment Act. The EEOC is there to educate employers and employees, serve as a resource to answer questions employers and employees have. They investigate complaints of discrimination, and if they feel it's warranted, they prosecute those complaints. And periodically, the EEOC adopts what they call a multi-year plan, the Strategic Enforcement Plan. And that exists to establish substantive agency enforcement priorities. And these priorities, when reviewed by you, give a roadmap on what the EEOC's goals are, what it's thinking, where it's focusing its energy and its resources. And the purpose of the plan is to focus and coordinate the agency's work over a multiple fiscal year period. And the idea is to have sustained impact in advancing equal employment opportunity in those years that they focus on. So now we've got the 24 to 28 Strategic Enforcement Plan. And the first thing they're doing is they're targeting discrimination, bias, and hate towards racial and ethnic groups, and they're including sexual orientation and religious minorities in that area. And this is an indication that the EEOC still believes that there's a great deal of work to do so that the playing field is leveled for racial groups, ethnic groups, religious minorities, and people with sexual orientation. They also want to expand efforts to address vulnerable, underserved worker priorities. This includes immigrant and migrant workers, developmental, mental health, and intellectual disabilities. Also, those with arrest records. And they have been focusing on this going back to 2011 when they handled a case against Pepsi-Cola at that time and talked about the impact, or the disparate impact, I should say, on people with criminal records who are African American and Hispanic. So what they've said is that it should not be an automatic bar for certain jobs if a person does have an arrest record. Sexual orientation, temporary workers, and older workers are also a focus of what they believe are the underserved worker priorities. Low wage earners, temporary workers, student workers are also a subject of this. And last but most certainly not least, gender-based violence. People who have been the victim of gender-based violence are an area that's focused on the new strategic enforcement plan. So there are emergent and development issues that the EEOC is focusing on. One example of a developing issue is the Pregnant Workers Fairness Act. And that's a recent law that provides protection to people who are applying for jobs and people who are working who are pregnant. And the goal under that statute is that if a person is able to perform the essential functions of the job with an accommodation that's reasonable, then the employer needs to sit down with the employee to explore ways to find that accommodation for the employee. Now, this is not any accommodation, it has to be reasonable. And I think the best approach is to look back at how you've handled reasonable accommodations requested under the Americans with Disabilities Act and apply that same approach for pregnant workers. One caveat, if an employee is eligible for leave in a jurisdiction where leave or there's a plan that the employer has that the employee can take leave under, or the employee can work with the accommodation, the goal is for the employee to keep working and to not take leave. The public policy reasoning is if the employee is able to continue to work, then the employee is still part of the employment community and is keeping up with what's happening in that workplace. Also, long-term COVID, long-haul COVID, is another area of focus under this part of the strategic enforcement plan. We get back to underrepresentation of women and workers of color, and part of this is because there is still a significant disparity in pay for women and pay for women of color as compared to men and white men. Now, increased use of technology. And I talked about today being a day where there's quite a bit happening. Earlier today, and if you're watching on tape, November 30, 2023, President Biden issued an executive order related to artificial intelligence. And part of that order pertains to the employer-employee relationship. And he directs the following additional actions being taken, again, the ones that pertain to the employer-employee relationship. Provide clear guidance to federal contractors and employees on the algorithms being used to exacerbate discrimination. Address algorithmic discrimination through training, technical assistance, and coordination between the Department of Justice, federal civil rights offices on best practices for investigating and prosecuting civil rights violations related to artificial intelligence. And essentially, this means that we're embracing AI as part of our future, but steps need to be taken to ensure that this does not result in discrimination against any part of our population. And last but not least is access to the legal system. And access to the legal system has been a continuing challenge for people based on fear, economic situation, and the lives they're living, and steps need to be taken so that all people can enjoy the protection and privileges under the law. Let's shift our focus to harassment prevention. The guidance in play right now goes back to the 1990s. We can all agree, hopefully, that a lot has happened since the 1990s. Think about what our lives were like in the early to mid 1990s. Smartphones, internet, social media, the increasing impact that has had on our lives. And we'll talk more about some of the other changes that have taken place in the past 25 years. There was some guidance that was proposed in 2017, but it did not go anywhere as it was not a priority for the administration at that time. Some of these numbers are pretty staggering. From January 2018 through December 2022, 35%, more than 1/3 of the charges filed with the Equal Employment Opportunity Commission included claims of harassment. Keep in mind that this is only the percentage of charges that were actually filed with the commission. This does not include claim letters and early resolution or charges only brought in state court. Think about the hashtag #MeToo and the renewed public focus on sexual harassment over the last couple of years. Think about racial harassment, which has been in the news quite a bit, and it's been a prominent issue. Now, in 1995, Mazarin Banaji coined the phrase implicit bias. And over the last couple of years, that phrase has garnered a tremendous amount of attention. And it has shifted to a large extent how trainers on harassment prevention, on diversity, equity, and inclusion, and how the EEOC and other agencies have approached harassment in the workplace. The first area that we're going to talk about is racial harassment. And this includes things such as racial epithets, offensive comments that are triggered by stereotypes, characteristics linked to race, and use of terms today that are no longer accepted. And we'll talk about quite a bit of that over the next couple of minutes. An example in the draft guidance is a Pakistani American, and by the way, this is from an actual charge that was brought, is routinely called turd by this person's direct supervisors. They tell him his skin is the color of feces. One of the supervisors actually puts feces in a cup and puts it on this employee's desk. And the EEOC found this to be an example of racial harassment. Use of Hagman's nooses, racial slurs, and stereotypes are other examples of racial harassment. National origin, similarly, ethnic epithets, derogatory comments about nationality, offensive comments towards, for example, indigenous people are examples in the guidance regarding national origin harassment. And the religious offensive comments that the guidance talks about focuses on things such as religious practices, stereotypes, and actually recognizes atheism as something that could be the basis for religious discrimination. One example that was offered in the guidance would be if a person is of a religion, for example, a Jewish person who keeps kosher and does not eat pork at an office barbecue, and then all of a sudden starts to receive religious comments such as, well, you don't need the job because you're rich because Jews own the banks, and kikes and other offensive comments could be an example of religious discrimination. And sex, the focus is unwanted or offensive attention. It could be verbal, it could be physical, it could be coercion, demands, pressures, remarks. Those are examples of sex-based harassment. Age, which has been a focus of the EEOC now for about 7 or 8 years, always, but an enhanced focus. And part of this is the recognition that people are working later in their life to keep a roof over their head. And some of the negative perceptions and examples given in the guidance include, you can't keep up, you're too slow, older people, they don't know technology, they don't understand the internet, they can't learn new things, they can't handle the physical demands. These are some of the negative stereotypes. And actually, this is a great example of implicit bias. Two people walk in for a job, they both are fully qualified. One of them is 30, the other one is 65. The 30-year-old, they assume, is up on computers, knows the internet, knows the technology, can learn software, can learn how to use different hardware. And the 65-year-old, too long in the tooth, they won't know how to do it. And that's an example of implicit bias. And that's the sort of thing that we're guarding against with these new laws. The next now is disability. And there's been a lot of attention, as I mentioned earlier, on things such as the impact of COVID. But there's also been increasing recognition of how important it is today to understand what are called invisible disabilities, mental health, depression, things of that nature. And there's a growing recognition that these are people who are not always as well protected and can be the victim of harassment and abuse in the workplace. So it's important that we make a concerted effort to address their needs as well. The harassment guidance talks about the fact that in order for there to be harassment, there has got to be an impact on the terms and conditions of a person's employment. And that the harassment creates a change in those terms or conditions. And there is a connection between the harassment and the terms and conditions. And it could be constructive changes. And the hostile work environment is one example. And this could essentially force a person to leave the job. The terms and conditions become so intolerable, that an ordinary person would have felt compelled to resign their employment. And that's an example of a constructive discharge. Then the Meritor case, which is a 1986 case, is a case that was the first one where the U.S. Supreme Court recognized that sexual harassment is protected under Title VII. So let's talk a bit more about what it takes for there to be harassment. And it's going to require that there is some action. And the action by itself isn't enough to make it illegal. It needs to be either severe or it has got to be pervasive. Severe would be grabbing a person against their will, touching their private parts, threatening the person that if you don't go out with me, you're going to lose your job. The hangman's noose. The example was the Pakistani where they put feces on the person's desk. That's severe. Pervasive means it happens enough times that combined, it impacts the terms and conditions of employment, so that a person is having a much more difficult time being able to do their job because every day they come in, they're subjected to this behavior. Now, it could be severe and pervasive, meaning these are some pretty serious things that happen and they're happening on a regular basis. Or the more severe it is, then it doesn't have to happen a lot in order for it to be considered harassment. And the guidance talks about how we should view each case based upon the totality of the circumstances. And each case should be based on its own merits. So in the eyes of the employee who's being harassed, we can look at whether subjectively that person believes that it's harassment, or objectively, really everybody in that workplace can find it to be harassing. Keep in mind that it is not necessary for the actor to intend to harass a person, the actor only needs to intend to do what that person actually did. Now, we've got 5 generations in the workplace. And each generation, in general terms, has different outlooks on the employer-employee relationship, what is expected of employers, what employers should expect of employees. And, in generalizing this, one thing is clear, is there is an increasing sensitivity to words and comments, things of that nature. So, for example, in the last couple of years, I have learned that the term master bath, master bedroom are terms that offend some members of the population. And I've done my best not to use those terms. Now we're also at a time where there are pronouns that people are using, and some people are pushing back and saying those pronouns are offensive. And because of that, again, we need to understand that repeated use of pronouns or terms like master bedroom, master bath, or some women are offended by the term female. Repeated use of those terms can create harassment in the workplace, especially if the person who complains about it has told the actor, please don't use those words. And that person continues to use the words and seemingly delights in using those terms. So the guidance also goes into great detail on liability. And I thought I'd like to spend a couple of moments on this briefly, but it's important to put in the back of your mind. If the harasser is a proxy or the alter ego of the employer, for example, a memo from senior leadership that says, we've got to get rid of a couple of the old farts, or I don't want any women working in that area in our engineering practice. And that memo surfaces, that's pretty much automatic liability for the employer. If the harasser is the supervisor and there is a tangible employment action, for example, the supervisor says to an employee, sleep with me or you're going to get fired, the employee says no and the employee is fired, then there's vicarious liability for the company. If the harasser is a supervisor, but there's been no tangible employment action, so for example, the supervisor does make advances to the employee, but doesn't threaten quid pro quo, do this or else, there might be vicarious liability, but a limit on its liability or damages. And this is Farragher-Eller. This is a Supreme Court case that goes back a couple of decades. Now, what the court said in Farragher-Eller is, if you create a viable policy and you disseminate that policy, you've trained on that policy. And if an employee believes that they have been the victim of harassment, then in that situation, the employer has an affirmative defense. Now, if the harasser is another person, for example, a person junior to the employee who's complained, or it's a third party, a client, a vendor, then the test is, has the employer been negligent by failing to act reasonably to prevent harassment? This could be creating the policy, training. And if an employee complains, failing to take reasonable steps to investigate the complaint. Now let's talk a bit about systemic harassment. And this has been routinely a focus of the EEOC, and this happens where there are a bunch of people who are complaining. For example, there's been a group of 100 people who complained that they were being harassed in fast food restaurants owned by a conglomeration, or a pattern of practice of claims of discrimination, in a company. These are systemic cases, and the EEOC gets excited about systemic cases because of the fact that, well, they can correct action that impacts dozens of people. They also get a lot of press out of it when the EEOC issues its press release and says, we're going after X Corp for one reason or another. Now let's talk about some tips. And here's where I suggest that you grab your writing stick. And your writing stick is your pen, your pencil, your crayon, your Sharpie. Because these are some of the things that's really going to be important to be able to take back and talk about with your team. The enforcement plan has a major focus on harassment directed towards religious minorities. Now, this plan was created over a period of time, but it specifically includes minorities such as Jewish people, and talks about anti-Semitism and Islamophobia. Pretty timely given what's going on in the Middle East right now. Now, it also talks about contested views towards harassment prevention and DEI initiatives. And there are in some states right now where there's been an effort by the legislature and the governors to prevent employees from having to, as they put it, be subjected to harassment prevention training in order to continue to work somewhere. This program is not about politics. And I'm not going to say that in states where they're trying to prevent harassment prevention or DEI initiatives, that one side is right and another side is wrong. I'm not going to say that in the Middle East, one side is right and another side is wrong. That's not the purpose of this program. But I think we can all agree that these views have an impact on the employer-employee relationship. In a company where a person who is a Palestinian and a person who is a Jewish person or Israeli are working together, efforts have got to be made so that they can coexist in the workplace without an impact for what's happening halfway around the world. In a state where harassment prevention training is something that's questioned by a governor, it does not mean that the employer does not have to take reasonable steps to ensure that no one's being harassed. And last but most certainly not least is the politics side, and that is whether you're a Democrat, a Republican, an independent, a hard left-leaning, a hard right-leaning, or a moderate. Let's do our level best to keep politics out of the workplace, however possible. It's important that we try to avoid that. Now, here are ways that an employer can be liable. A person goes on record saying, I support Israel in what's going on in the Middle East, and an employer finds out about that and fires the person. Conversely, a person says, I'm supportive of the Palestinians and I'm angry at Israel, and that person gets fired. They've got potential claims of discrimination. And what do you do as an employer to get out ahead of potential harassment in the workplace? Think about steps you can take. Do you have a town hall? Do you do training? Do you send out notices to people about what you expect of your employees? That's something to consider seriously and try to get one step ahead. I talked before about the Pregnant Workers Fairness Act, and if you have not already done so, make sure that your supervisors, your HR team, and leadership know about the Pregnant Workers Fairness Act and know what's expected of a company. So, for example, we have Beth, who is pregnant, and she's working for, Fast Foods Delight. She's 4 months pregnant, and she is searching for some form of an accommodation because she needs to take breaks to go to the bathroom, and they expect her to be on the floor. And supervisor or the manager for that location says, no, we can't have that. We can't afford to have someone else covering for you while you take a break for 15 or 20 minutes. And that person's thinking about making sure that that location is profitable. And if they have to have another person working, then they're not going to be as profitable. What that manager should be doing is going to HR and asking HR, how do we handle this? But if the manager is not made aware of the fact that there is a Pregnant Workers Fairness Act, that manager is going to make a mistake. Not understanding or appreciating the long-term effects of COVID-19 and the fact that it has created medical issues that can extend for a prolonged period of time and maybe even permanent, who knows? But it has had an impact on employees. And like the silent forms of disability, managers should know beforehand how to respond when people bring this concern to their attention. And the technology-related employment discrimination. Find a way to audit your system. Now, if this, for example, is your system of screening applicants when people apply online for positions, and we've seen a number of cases involving AI technology screening applicants and eliminating applicants from poorer neighborhoods, applicants who the system concludes are older, applicants who are women and minorities. So however you can go about doing it, I implore you to think about finding ways to screen your system before it wrongly screens applicants. So I talked about this Farragher and Eller, and this is something that is not new, but more than ever, it's real important. Because perception that people have remains in far too many companies. This is not a place where you can bring a complaint to the attention of HR without either being terminated or marked lousy by the company. And so long as that remains the perception, employers may lose the Farragher-Eller affirmative defense, which means that there will not be the limits on liability or damages if a claim is brought. Moreover, if the perception remains this is not a place where you can bring a complaint, then employees are less likely to complain, which puts the company at risk of having multiple lawsuits brought if there are multiple people who've been harassed, and larger awards of punitive damages because of the fact that the complaint system is not viable. There's also unwanted turnover. People leave. I'm not going to work there anymore. I don't like the way that people are treated. Or they're going to stay, but they're not going to be as engaged. Productivity stalls. And if they are the subject of a notice from the EEOC of a charge of discrimination or a lawsuit's brought, there's a huge impact on brand and customers. The best way to address this is to make sure to, on a regular basis, sell the concept that we want this to be a great place to work. And as part of that commitment, we are doing this program, we're doing this initiative, we're involved in some form of a charity. And that is a huge step in the right direction if that's something that you can do. And the impact on this guidance is going to be public attention that the EEOC is focused on protecting people based on race, gender, national origin, religion, age, disability, etc. And pretty much every person falls into one protected category or another. Now, the Bostock case, which came down in 2020, so it's still a relatively new case, held that sexual discrimination can include sexual orientation and transgender status, gender identity, and things of that nature. And as a result, when an employee makes a complaint and says, I'm being treated badly, excuse me, because I'm gay, I'm bi, I'm trans, what have you, then that needs to be treated every bit as seriously as the complaint of sexual harassment of a man on a woman. Now, in addition, they have talked about the refusing to use the proper pronouns and asking about sexual anatomy and whether she has had gender affirmative surgery and referring to the individual by her previous male name as examples of harassment against a person who's transgender. And that's a charge that was made to the EEOC. Left unsaid, left unaddressed, is that the guidance does not talk about a split in religious beliefs and gender identity if a person's religious belief prevents the person from using a colleague's preferred pronoun. So if a person believes it's against her religious beliefs, that to recognize a person who's transgender is going to be more persuasive, the religious belief or the sexual orientation issue. And that has not been addressed in the guidance, but that's something that's going to need to be followed. Now, some of the cases that are described in the guidance include, implicit bias towards people based upon, for example, if they have dreadlocks, other hairstyles, tattoos, body piercings, they wear religious garb, whether it's a yarmulke, headdress, and individuals' names. These are some of the other areas that are addressed in the guidance, and it's important to, number one, teach your employees to refrain from commenting about another person's characteristics, whether it's the food, the music, if they need to go to prayer at a certain time of the day, what they're wearing, to refrain from commenting on it, teasing people on it, harassing people on it. And even if you're not trying to make a person feel badly, but you talk about it, remember what I said, intent does not matter when it comes to harassment. You just have to intend to do what you did or say what you said. One of the impacts of the pandemic was the rising number of people working remotely, and that's addressed in the guidance as well as in the strategic enforcement plan. Contact in a virtual work environment still can become a hostile work environment. So even if you're working remotely and you're making comments on a phone call, on a video meeting, you're wearing inappropriate clothing on a meeting, you've got some sort of a racist imagery on your screen or the background, that can still create harassment. So picture this. I'm on a Zoom call with you, and I'm in my pajamas. You might feel uncomfortable. If I stand up and I only have boxers on, it can make you uncomfortable. You know, if I've got KKK images behind me, it can make you feel uncomfortable. Now, if I'm routinely calling you during your lunch break, but I don't call other people during their lunch breaks, that can make you uncomfortable. There are ways that people interacting with remote teams can still create harassment. And in addition to that, the guidance also talks about inappropriate comments made on Facebook, LinkedIn, texting, emails with the people you work with. So if you are frustrated by somebody and you feel that they've treated you inappropriately, bring it to the attention of HR. Follow whatever is in the guidance. As an employer, be as sensitive to complaints regarding remote harassment as you would be for things that have happened in person in the past. And I think that's your step ahead. If your personnel policies don't cover remote workers, you may want to upgrade them and update them to what is the line in terms of how you communicate with people remotely. And those are the issues I wanted to address today. I know I threw a lot at you, and I'm happy to talk shop offline with anybody who's been on the Zoom today. My goal is to help you get out in front of issues before the issues become challenging. I'd rather have these kinds of conversations than have you call me up and say, we just got served with a complaint, and we felt that was avoidable. So again, thank you very much for joining us for this program. I hope that it was helpful to you, and I wish you a very good day. Bye now.